The point of this is we're going to go into the micro details, but please don't lose sight of the big picture. You know, the reason for this legislation is not to be the bane of elected officials' lives. It's to allow for transparency in government. The preamble to the Open Meetings Act spells out that for representative government to take place, there needs to be an informed electorate, and that's why meetings for the conduct of government have to be open to the public. All right, so that's just a little bit about the history of koma and why it applies. So let's talk about when koma applies. And the first part is, you know, you have to have two elements for koma to apply. First, the body has to be a covered entity, and then you have to have a meeting. So what do I mean by covered entity? And for you, it's easy. It means a city council, of course. But when you look at the definition, it's not that clear. You know, a covered entity is all legislative and administrative bodies and agencies of the state and political taxing subdivisions thereof, including boards, commissions, authorities, councils, committees, subcommittees, and other subordinate groups thereof, receiving or expending and supporting in whole or in part by public funds. So what does that mean besides your council? Well, it means all your committees, your subcommittees, commissions, boards, task forces, anything that's under your city council that you've appointed will fall under koma. So like your Parks and Rec board, and your planning commission, and your board of zoning appeals, they all fall under koma. Certainly that's not always that simple to determine if an entity falls under koma. Sometimes you really have to dig into the specifics and look at the facts, and we're not going to talk about those today, but if you, just because each one is so fact specific, but if you look at pages 6 through 8 of your book, you'll see, I'll find it here, like page 6 through 7 has entities covered by koma according to the Attorney General's office. And then 7 through 8 has a list of entities not covered by koma according to the Attorney General's office. So that gives you a little idea of the different entities that could fall under koma. So we know you're a covered entity. So the next question becomes, when does a meeting occur? You've met that first element, so now you have to meet the second element of when is there a meeting. And koma is triggered for a meeting to happen. There must be a majority of the body, you must be engaged in interactive communication, and you must be discussing the business of the body. And you need all three of these elements to apply. So let's take a closer look at the first element, a majority of the body. And what does that mean exactly? Well, it depends on your city's form of government. So a majority for you as a city council form of government refers to the number of regular voting members of the governing body. Because Merriam has a mayor that does not regularly vote, you do not count toward the quorum. You only look at the city council in this calculation. So in this case, 5 would be a quorum because you have 8 council members. So to reach that first one, that first element, you need 5 council members. A common question that we need to receive, so we get quite frequently, is does koma apply to city staff? And often individuals will mistakenly believe that koma applies to city staff like the city administrator, city clerk, or city attorney. It's not uncommon for someone to get upset, for example, if they see a council member talk with a city staff member during a meeting and then complain later that they violated koma. But there's no way for that interaction to violate koma. Koma does not apply to city staff, and it doesn't apply to your mayor either. Staff can have a conversation with an individual council member without triggering. Now, if you had a staff member and 5 council members, or the mayor and 5 council members, you would still have to follow and see the elements. But those one-on-one communications do not violate koma. So, once you know you have a majority of the body, 5 council members, then you have to look at the next element. Is there interactive communication? You know, there needs to be a back and forth. One of the examples that was given when I first started at the league years ago was, you know, just writing a letter to someone and sending posting letters in the mail and writing them back. That was an interactive communication because it really has to be pretty fast in time. It can't be days apart. The communication can't be days apart. And honestly, when you think back of when koma was first enacted in 1972, there were very few ways to communicate interactively. Talking in person and over the phone were really the only ways to do it. Now it's no longer that simple. Technology provides for many ways of interactive communication. Because of course we have emails, text messages, group chats, Zoom, WebEx, FaceTime. They can all be sources of interactive communication. You know, what if a council member posts something on Facebook and another council member likes it? That's probably interactive communication. So you have to be very careful about what you do. We frequently get asked, is it okay if a council member sends an email out to everyone on the governing body? And really, at this point, email is kind of getting outdated. Or what if they send a text to everyone? You know, does that violate koma? And hear me out here. The short answer on that first email or that first text message is that it's not a koma violation. And it's not because there was no interactive communication. It was just one person sending the email or one person sending the text. But there was no reciprocal exchange. The problem with that, and the reason why you would probably have Chris or someone and going, stop, don't reply, is because it takes you down a slippery slope. And if one council member sent a text or an email like that, and then another council member hits reply all, even if it's on accident, and responds, that's where you get the interactive communication. That's where your mutual or reciprocal exchange is. So, of course, at the league, we always recommend refraining from emailing everyone, because even though that first email may not violate koma, it's out of your hands after you hit send, and it could easily turn into a koma violation. And I don't know about everyone else, but I noticed on my email app, I have to purposely go in and take it off of reply all and just hit reply so it goes to the one person and not both. So it's just so easy to do that. Another frequent question, we've been getting more and more, is what about group text? So can the governing body be on a group text together? You know, what if it's just a message from staff reminding you of meeting times? Because I've heard that from city clerks, that's the only way I can communicate with my council. They want text, and it's easier to say, don't forget the meeting at 7 and send it out to everyone, right? And that always makes me a little nervous. My advice regarding group text, and I'm not suggesting that anyone here is doing it, but my advice is to just completely refrain from them. And if you're doing it, you should stop doing it. You know, while a staff member's update on a group text is violating koma, like saying, don't forget the council meeting at 7 o'clock now, that doesn't violate koma. If there's a majority of the body, and suddenly other council members are texting, you have interactive communication. And then if you get the third element we're going to talk about, you have a meeting and you have violated koma. So you have to be so careful there.
So could just for clarity's sake, as long as no one responds to the text,
right, that's fine.
You are legal.
You are legal. So no one should respond. But my advice is just, I know it's a pain, but just send an individual text. Or send a text out to 4, so you don't hit the majority. Right? Just same with emails. When I first started at the league, I think in 2010, and the attorneys at the time there were like, don't email at all. And I thought, well, that's silly, everyone's going to email. And with email, you just need to blind carbon copy people. So when they can't hit reply all and send it to everyone, they can just reply. And same with group text, I think you just have to be careful and not have a majority, because you just don't want someone to even accidentally think they're texting you and it turns out to be the whole group, right? You just have to be careful with that, so.
And sending that little thumbs up emoji would be considered a block.
all it is, I don't think it's a koma violation. If it's like, you know, if you're sending a thumbs up to should we buy the snow blower, then that's a problem. And you laugh, Dennis, actually have, some people have come up to me after training and said, oh, during the meeting, that's what we were doing, and we stopped. So, like, that's, that happens. I'm not suggesting you do it, but people don't even realize that that's a problem until, you know, they learn. So that's why you have this training. When you're just discussing a meeting, like, and when I say, when you're discussing the time of the meeting, like, don't forget we have a meeting at 7, and if someone hits a thumbs up, that's not, well, that's not the, that does not meet all 3 elements.
How about a text from the city administrator to the entire governing body that says, someone got shot on the highway, and the KDOT's on the scene, and the highway patrol's on the scene, and I'm going to craft an email with all the information that I know, stand by.
So you can text chat, that doesn't violate koma. If you don't, you can't violate koma, essentially. But then.
As long as they don't respond.
As long as they don't.
Definitely can't.
And that's why I think it's just better, because if suddenly it's like, if it's a response of like, okay, keep us updated, well, that's not, you know. But if it's, oh, it just takes you down that slippery slope. So that's why, and I realize especially in those situations, you want to get the communication out and you want it to be done and over. But I think it's better to maybe have 2 groups and split them up. So that way then no one accidentally even just hits a group on accident one day, right? And even in my group chat, have you done this before where I send a text to the wrong person and I was like, oops, that was meant for this person, and you know, you just have to be careful.
So if Chris sends that out to 4 council pushes, same message, but to these 4, he's okay, even if they respond back.
Yes, because you don't have 5. So he can have you and 4 council members, and 4 other council members, but you don't have a majority, you need 5 council members.
Because I'm not part of that group.
Right, because you're not part of the group. So technically, Chris could be in a room with 4 council members, and they can talk about all the city business they want, and koma is not violated because there's not a majority of.
And you all are pretty well trained, like we push an email out, we put at the top, do not reply to all the common considerations. I've never seen anyone run afoul of that, so just be mindful.
Right, I'm not suggesting that you do this, it's just, it's easy to accidentally. I did it the other day, I sent something to my family, and I was like, oops, that was meant for my husband. And it was just about how much it snowed. I was asking him if it was snowing at home, and I'm like, never mind. My family's in Omaha, this doesn't even make sense to them. But it just happens, right? So, anyway, at least I was out of state more than I should probably. All right, so if you have interactive communication, if you have a majority of the body in interactive communication, the next element you have to have before you have a meeting is you must be discussing the business of the body. So this includes any city business, you know, and it's not about notices for meetings, it's about other city business, like about the pothole that needs to be fixed on a nearby street, or a contractor taking action, or a tree that was just planted somewhere, right? It's any city business, this does not have to be binding action in a meeting. So you have to be very careful with that. This does not mean a majority of the members of the governing body can never talk. You can all attend a barbecue, right, at one of your houses, or have dinner at a restaurant. The key is that you don't talk about city business in those situations if you haven't noticed it as a meeting. Also, of course, if you don't technically violate koma, you still want to be careful because the public perception that a violation occurred, even when one was not committed, goes a long way, and you want to avoid that appearance of impropriety. Okay, so we know meetings occur.
I'm sorry, Cora, I just want to make
No,
sure.
it's okay, I'm glad
You
I
said
asked
that
the
that would be a violation, but because I've never done this, but not say I'm waiting. But if I wanted to have a backyard barbecue at my house and invite the entire council to just 4 at a time, that's okay?
As long as you don't.
As long as we don't discuss business, right? Okay.
And it's tricky because this is how you know each other, right? And so your tendency might be to slip into start talking about city business.
Right, you have to be careful.
Yeah.
But if you did not talk about city business, I know this was always something too that came up when I first started the league. There was a city that had several council members all working on the same little league. And the city administrator was so afraid that that's how they only really knew each other, that he noticed all the little league meetings, or all the little league games as meetings in case, you know, they talked about it. So you do want to be careful, and you know, what will people think if you had that many people over at your house? But you can definitely, the point is you have to be talking about the business.
So we have counties in Kansas that have 3 county commissioners.
Mm-hmm.
So anytime 2 of them get together, they have to deal with this whole.
Yes, if 2 of them talk about county business, they have violated koma. It's very hard when you have 3 commissioners.
Yeah.
It's very difficult. Yeah, you have to be so careful. So we have the meetings where you have a majority of the body, interactive communication, and then you're discussing the business of the body who violated koma. But then we also have serial meetings where you can violate koma. So in 2008, the legislature added serial meetings as a type of meeting required to be open under koma. And there are 3 elements to determine if a meeting is a serial meeting. So first, it has to collectively involve a majority of the membership of the body. So again, this means you have to have 5 council members. You have to share a common topic of discussion concerning the business or the affairs of the body or agency. And it's intended by any or all participants to reach an agreement on the matter that would require binding action to be taken by the body or agency. So let me give you an example, because I feel like just looking at those elements, it's hard to understand. Let's say you have an upcoming meeting where you're going to vote on someone for the planning commission. And someone does not want to vote for that person, we'll say. So, and I'm just making this up, so if this has happened recently, I did not know about it. But for the purposes of this hypothetical, we'll say you have council members A, B, C, D, and E, the 5 council members. And let's say council member A does not want to approve this appointment for whatever reason. So council member A texts council member B and says he isn't going to approve this appointment, and asks council B what they're going to do. And council member B responds and says she's not going to vote for the appointment either. That one communication on its own does not violate koma, right? Because it's just 2 council members. You are interactively communicating about city business, but you don't need that first element because it's just 2 council members, not 5. So let's say then council member A texts council member C and has the same communication. And C says the same thing, I'm not voting for this person either. And then A texts council member D and they have the same communication, and D agrees, yes, I don't want to appoint this person. So then council member A is worried, well, we know we have 4 votes, but I think E might be on the fence, so I'm going to text E. And they text E and say, hey, I've discussed this with council members B, C, and D, and all 4 of us are going to vote against this appointment. Are you with us? And that right here is where you get the serial meeting. Because you've collectively involved a majority of the body, there's 5 council members, even though it was one-on-one communication, you've told council member B how A, B, C, and D are voting. So that gives you the majority. You shared a common topic, you're talking about the planning commission appointment, and then it's intended by any or all participants to reach an agreement that would require binding action to be taken by the body. So, okay.
So even though B, C, and D didn't know that A was gonna reach out to E, okay.
Because A really did it with that, with that communication.
Would it have been a problem if A still reached out to E and just said, hey, what are you doing, instead of also saying B, C, and D are?
That's a close call. I would say probably not, but I also think But don't do it, and I think you probably should take a more conservative approach with this current administration taking, with COVID. That's what I would say. But no, I think you could probably have those communications and keep it to yourself, essentially. But you just have to be so careful. But once you start saying, hey, we've got these 4 people, are you gonna be with us? That's where you violate koma. And the first time this happened in a serial meeting, it was actually with, a committee of, one of Johnson County's committees. And it was, I wanna say the Parks and Rec Committee, but I can't remember for sure, so I don't wanna call them out. But essentially, the person wanted to remain the chair on the committee for another year, and that wasn't typical. And so the individuals sent FaceTime messages to the different members on the board. And they all responded like, yeah, that's fine. And he got to the last person and said, everyone's on board with this. I would like a unanimous decision. Can you vote this too? And there was that trail of, and that communication, that final communication, where he told everyone, where he told this last person how everyone was going to vote, that's what they said violated koma. So. And that's where you get in trouble, with all the new technology. All right, questions about that? You're all asking lots of questions, so that's good.
Does it matter what device you use, if it's a personal device or a device provided by the city?
No, any device, as long as you're interactive communication, it doesn't matter. It will matter for Cora, we'll get into that, but not for
I assume that would I have the ability to violate serial meetings if I were to reach out to individual council members and ask them about a proposed policy? If at some point in time I said, well, I talked to everybody, like you said, well, hey, just so you know, I talked to everybody else is cool with this, are you good with this? 'Cause I assume, despite the fact I'm staff, that's still.
Technically, you can't violate koma, but if you're doing it in the spirit of like, well, if they're asking you to do it to see how then I would say you've at least violated the spirit of koma and shouldn't do that.
But if I'm saying, hey, I keep up frequent communication with the governing body on one-on-one basis and a group basis, but, I'm going, hey, there's a situation that's happening and we're thinking about doing this, what are your thoughts? They tell me what their thoughts are, then a week later I meet with another council member and go, hey, catching up, and hey, this is what's going on. And I'm not sharing, I'm just kind of formulating how to structure that piece of policy to be in front of them. I'm not in violation of it.
No.
Even though I might already know how all 8 of them feel about this piece of whatever it is we're gonna put in front of them.
Right.
They don't know, there's been no interactive communication.
Right, and you really can't violate. And the same goes with we've had this question where, can I even talk to the newspaper, because then if my opinion gets out there, everyone on council will know, and they're asking all of the council members what their opinions are, and we shouldn't be answering that. But really, someone from the newspaper can't violate koma. So you could individually talk to the newspaper, and they can report it, and that koma isn't violated. And I say that because that is actually an actual question I come up with.
I responded to a group email 4 days later. That falls in that time window, could have gone by mail.
That's a good question, because in 2010, I'm not kidding, email, we didn't have it on our phones, and maybe you didn't even have the internet, I don't know, and we talked about how if you didn't email wasn't always an immediate response, like it is now, right? Or like texts are. And so if you sat on it for days, is that interactive communication? It may not be. It's a great
Still wouldn't
area.
do it,
But I joke, you can fax each other. Somehow we still have a fax machine in our office. And on occasion it goes off and it scares me. What is
You don't know what to do with it.
I don't know how to report it. Anyway. But, okay. Those are good questions, but I don't think people sit on emails recording anymore, unless they really don't want to answer.
All I know is-
If I could get a response from Jacob in 4 days, I'd call that,
Okay, fine.
communication.
It depends what the email is.
Okay,
I
that's
asked
fair.
other staff how often they
Got sent a text, so he's reading the paper.
That's fair, see, that's, yeah, all right. Well, that's the kind of overview of koma. Let's talk about some requirements, and a lot of these I know you already know. But first, of course, koma requires open meetings, except every part of the meeting that any valid we call executive session. And we are going to get into talking about executive sessions. Meetings must also be accessible. Koma does not require that the governing body hold every meeting in City Hall. You can hold meetings in other places. There may be reasons to have meetings elsewhere, but it needs to be accessible for everyone. Also, online meetings are allowed, but a city should have an area for members of the public to view the meeting. So let's say your meeting had occurred on Saturday night, when it was really stormy, but you still wanted to have the meeting, you could put everything online, but you would still need to open up a spot at City Hall or somewhere for the members of the public to go who wanted to watch your meeting, but maybe didn't have access to the internet.
You have to do both.
To-
If you make a space available here at City Hall for people to watch a meeting, but not stream it online, do you have to do both of those things?
Oh, you mean like just have the Zoom but not stream it?
Well, if
online?
we met somewhere else offsite and we had a streaming option here,
That's a good question that we can talk about. I would need to look into that a little more, because,
versus streaming to somebody in their home and here.
you mean like, can you give me an example of like where you go to meet somewhere?
Yeah, because you said you have to make either a space accessible here in the building and stream it to the internet.
That's if the meeting's fully online. Does that make sense? So
Yeah.
like this was really a rule that happened during COVID. And then when everyone moved their meetings online, because no one wanted to be, you couldn't meet together. And then after COVID, some meetings, or when everyone could get together again, some meetings were still happening completely online, which is 100% fine, but that's when the Attorney General said, well, you can do that, but not everyone has access to the internet or computers, so you need to open up part of your City Hall so they can watch it and stream it. So it's not necessarily about holding it in another place, it's about your whole meeting is online, everyone's like at their house, on Zoom, conducting the meeting, individually from their computer.
Yeah, so if we do that, we have to have both options available.
I would, yes. Sorry if I misunderstood your
So
question.
you could meet somewhere else, but make the meeting accessible here.
You can have the meeting online, right?
So we do, I
Everyone's
don't know if you
meeting
remember,
from
we
their
do a
home.
CIP tour. So we put people on the bus, drive them around on the bus.
You're
So-
setting me up.
So if we were to broadcast that on Facebook or Zoom, and we were to broadcast it only here into City Hall, could residents come here to City Hall and watch it? And because, we've got thousands of residents, we're not running that big of a bus.
Right, I understand. And I also, can I get back to you?
Absolutely.
Okay. All right, any other questions about that? Okay. That rule about the online and having a place, it's specifically when your meeting is 100% online.
But we are not compelled to broadcast online all.
No. And you don't have to broadcast.
We're not.
You would just have it on space here.
Yes, if we had, had a horrible blizzard and you had to have a special meeting to approve something, right? Like, you had to do it that night. You could all Zoom in somewhere and have the meeting and be safe in your house, but someone would still have to come to City Hall and open it up for a space for someone to watch it. That's basically what the Attorney General has said.
So that's specifically if you have to go on things and stuff. So like in the first suggestion or scenario, the CIP tour is just us driving around the city talking about city.
But it's still a meeting, because it's still a majority of the, like for 5 people in the bus, it's everyone in the bus, so you have a majority of the body, you're interacting, I'm assuming you're talking and you're not just sitting there. Right? everyone's talking at some point. Or if you're all just sitting there and listening to Chris talk over the speaker or whatever, or whoever about, then that would be different. That wouldn't be a meeting because you're not interactively communicating.
Or Caitlin gets a really great tour.
See, or Caitlin, Caitlin's over the speaker, whatever, like you're on your tour guide, I picture a tour, and no one is talking or asking questions about city business, that's perfectly fine.
I wouldn't say they were all talking about city
City
business
business, right.
most of the time.
Okay, so. Get back on topic. No, but yes, those are work sessions. They're still, no matter what you call them, they're still a meeting. Just like a group text with 5 people texting each other about city business, that would be a meeting. Right? So also, KOMA requires you can't have any secret ballots or actions, so when you're taking binding action on something, you can't do it via a secret ballot. You have to have notice of meetings, and there are specific notice requirements. And then, I guess, actually, this is just my list here. Copies of agendas, I skipped ahead. There we go. Notice of meetings, it requires notice of date, time, and place of any regular or special meeting to any person requesting notice. So, essentially, as long as you provide that information to anyone who's requested notice, you've fulfilled your KOMA obligations. So another question we often get at the league is like, do we have to put it in the paper? Do we have to post it on Facebook? Do we have to put it on our website? How much time and notice, hours do we have to give? A lot of people, for some reason, think it has to be at least 24 hours. In the end, notice needs to be reasonable. So if you've known about that you're going to have this special meeting for the last week, you should probably give a little more than 2 hours notice, right? But if it's a special meeting, a tornado has, I don't want to wish any, but if something terrible has happened and you need to have a meeting in an hour, then you give as much notice as possible. And the only thing you have to do is tell the people who requested notice, putting it on your website, putting it in the paper, putting it anywhere else is just extra. So it's a great thing to do. I know you reach more people that way. But if you've had 5 people ask for notice of your meetings, telling those 5 people are the only thing you have to do. Other things you can request, and I'm sure Julie probably does this, you can request notice. You can request that people fulfill notice requirements every year to make sure they still want to get notice. And then if you ever are going really late one night, let's say it's midnight, everyone's done, but your meeting isn't over, you can essentially adjourn the meeting and say the next time and place that you'll meet, and that's all you have to do. Alright, now let's talk a little bit about agendas. KOMA does not require agendas, so that's always a surprise to people. I think agendas aren't required in the state of Kansas. You're not required to prepare one before any public meeting. But if you do have one, then the agenda must be made available to anyone requesting notice of it. And I know you have yours online, so that's already been fulfilled. The agenda may be amended during the meeting as long as you don't, and I'm not sure, as long as you don't have a local council policy against it, you can always amend your agenda during the meeting. Of course, the league cautions against that and try to do that in emergency situations, just because then you can always have the complaint that you're not being transparent.
It's certainly not required that if we have a presentation you're gonna give, that we have to put it in. If we chose to put the presentation that we were gonna show at council, that's not required by statute. That's,
You don't have to put it on the packet.
In the packet.
yeah, in the packet. Like if we go, hey, for this item, we've got a 6-page PowerPoint.
It's listed on the agenda, but not that PowerPoint.
It's an item.
Right, you don't have to put it online.
So the fact that when we do put it in there, that's value added,
Right,
more transparent.
right. You just have to, and you don't even have to put the agenda online. If someone asks for the agenda, you have to provide it to them. And then someone can make a quorum request of the PowerPoint after it's been shown to the council, and we'll get into quorum. But once something's shown to the council, you have to provide it under quorum. So in that way, you would have to provide it, but you don't have to provide it. Just the agenda, if it's prepared and someone asks for it, then you have to give it to them. All right, and then I think everyone knows this, but you cannot prohibit the use of cameras or lights or recording devices. I mean, you should just assume someone is always recording your meeting. You may establish rules to ensure the meeting's orderly conduct. So you can, like, and I think you already do this, but like with a news station, you can say, like, everyone's cameras need to go in a certain area so that everyone can see, right? You can do that. Or if someone was walking around with their phone and their iPad to try to get the sound better, you can ask them to go to a certain location to record. That's perfectly fine. You can have reasonable rules, you can't just prohibit that. All right, questions about any of that?
I have a good question.
Yeah.
What if a quorum cannot be met? And that's not determined until the start of the meeting? Is that a quorum violation?
No, so you only have 4 council members? Is that what you mean, like?
I got a smaller committee like me that just has 3 members,
Oh, yeah.
and one doesn't show up.
That's, you haven't violated anything, you
You
just
did.
can't have a meeting, basically. Or a
So
blind
even if
meeting.
public showed up.
Yeah, that's, you can't control that. And that has happened in some cities where they can't get a quorum, and so they have to adjourn to the night another time.
That's what our ordinance says. It says, whoever's there can convene it for the purpose of compelling the attendance of an absent members, and that's it.
But they could have the meeting, just not vote, or they
It
can't even.
doesn't really count as a meeting, so,
Okay.
yeah, you can't have a meeting. I mean, but nothing happens, you just can't have a meeting. People might complain like, why did I come to this, but no one's in control. All right, so let's talk about executive sessions, which starts on page 23 of your manual. And as we discussed, every part of the meeting except validly called executive sessions must be open to the public. So what do I mean by validly called executive sessions? There's 16 justifications for recessing into executive session. The koma manual provides all 16 for pages 23 to 27. We're not going to talk about them all because they don't really all apply to cities. I'm just going to touch on the ones that cities use the most. And everyone knows this, but I always say as an important rule from the outset is that you cannot take binding action in executive session. Any binding action must occur in an open meeting. So, let's talk about some of these justifications. So the first one that I think is used often is to discuss personnel matters of non-elected personnel. The purpose of this justification is to protect the privacy of public employees. So you can use this justification to talk about individual city employees, to discuss issues related to hiring, firing, compensation, and discipline. For example, if you were working on your city administrator's performance review, or to discuss terminating the employees, right? So you can go into executive session for that. Or if you needed to interview prospective employees, they also fall under this, or to discuss potentially hiring people. This justification is not permitted when you're discussing general personnel issues, so like employee benefits, personnel policies, anything that applies to city staff as a whole and not just individual employees. Anything that applies to city staff as a whole should happen in an open meeting. This justification also does not apply to the governing body. So you would be surprised, I think, but there are occasions when we get a call at the league asking if the council or commission can go into executive session because they're upset with another governing body member and they want to talk to that person as a group, but they want to do it privately, not embarrass them in front of everyone at the meeting. But you can't do that. This is only for individual city employees. about an independent contractor, like a vendor, or a city attorney, or someone else they may have on contract, and this justification does not allow for that. It's specifically for individual employees. So, the next justification up there is consultation with an attorney on a matter that would be deemed privileged in the attorney-client relationship. And of course, this doesn't mean every conversation you have with your attorney would fall under this. I know Ryan would tell you when you needed to go into that, right? So we're not going to worry about that. But the key here, and you may laugh, but this has happened, so this is why I talk about it. The attorney must be part of the executive session. So there have been occasions where cities have not taken their attorney in, and they've used this, and then someone, the mayor, or another city staff member says, I talked to the attorney, and this is what they've told us, and that they've been found to have violated code for doing that. Now, if needed, Ryan could call in, like he doesn't have to physically be there, but he needs to at least be on the phone and talking to you that way. Other ones, and I don't know that you have to worry about this, but employer-employee relations and negotiations. And then also to discuss data relating to financial affairs or trade secrets of second parties. So this justification is used in the context of economic development when you're trying to encourage a particular company to come to your city. You can also, and I know it was on your agenda tonight, so you can recess into executive session to discuss the acquisition of real property. But this is only for the acquisition of real property, not the sale. That's something we want to distinguish. And as we talked about, you cannot take binding action in executive session, but you can come to a consensus. So you may come to a consensus that you want city staff to pursue purchasing a property up to a certain amount. That's perfectly fine. But you cannot approve the purchase until you have binding action in an open meeting. Another reason to go into executive session is to discuss matters relating to security measures. So if the discussions of such matters in an open meeting would jeopardize such security measures, so this is like if you're going to talk about a cybersecurity plan or any other security plan that having it out in an open meeting for the public to know would jeopardize those measures. Okay, let's talk about the proper procedure for going into executive session.
Can we go back to
Sure.
number 4 again?
Yep.
So financial affairs and trade secrets, this deals with economic development. So we have a development deal going down. We go into executive session, we talk about the terms.
Right, it's to discuss data relating to financial affairs or trade secrets of corporations, partnerships, trusts, and individual prior. I always have trouble with that.
So Councilman, typically what we do when we're doing echo dev stuff is we'll have outside legal counsel who's advising us. They're gonna be the ones who come in and consult. So we're gonna adjourn into executive session under the attorney-client privilege. So he's giving you information, providing legal advice and soliciting feedback versus that exception is really more, if you were to disclose, financial statements, such that you could, we're trying to determine whether someone had the financial wherewithal to do a project. That's typically something city staff and its consultants are gonna look at rather than you. So, does that answer your question?
I think so.
Yeah.
It's probably rare that you use this one, but smaller cities may use it to talk about, like, if they're getting data from a company, that's when you go to them. But here, yes, you probably do the attorney-client privilege one. It's just an option. I don't know that number 4 is not one I see very often, but it is there as an option. All right. So let's talk about what KOMA requires for executive session. So KOMA requires a motion. KOMA requires you to record the motion in the minutes. And KOMA also requires that you return to an open session So even when executive session is at the end of the meeting, that's why you have to come out and then adjourn your meeting. That's what's required by koma. So let's talk about the motion to recess into executive session. The motion must include a statement describing the subjects to be discussed during the closed or executive meeting, the justification listed in state statute, so one of those 16 justifications, and then the time and place at which the open meeting shall resume. And here's an example that's in your book as well, but essentially, I move the city council recess into executive session to discuss an employee's performance review. That means the first requirement, the subject to be discussed. Pursuant to the non-elected personnel matter exception, KSA 75-43(b)(1), that's your justification by state statute. And then the open meeting will resume in the city council chamber at 7:25 p.m. And that's the time and place to resume. And this is just one example. If yours doesn't look exactly like this, it doesn't mean that it's wrong, but this is just one example of how to do it. You could go into executive session to discuss more than one subject. So for example, if you were going into, for several reasons, for elected personnel, you could list the subjects to be discussed. You can do that for more than one. So if you're doing a performance review and then some other personnel matter, you can list those two subjects in one motion. You cannot have two justifications, however, to go into executive session. So if in the same night you're conducting a performance review and you're talking about acquiring property, you have to have two separate motions in that case.
Do you have to come back into general session and then we go back? Okay.
And I know your motions have who is attending your executive session. That's, a lot of cities do that. That's not required by law. I think it's a great best practice to do, especially when attorney-client privilege, because then you can say, oh, our city attorney was there, or our special counsel was there. If it's another matter where you have outside counsel, you can say who's there. But you don't technically have to do that under the law. You're just going above and beyond.
Real quick, we've done this several times. In order to extend executive session, we will sometimes only send 5 people, which is a quorum, down to extend executive session, rather than the full governing body. Is there any issue with that?
As long as you have 5, right, that's what you need to do business, and so I think that's fine. Yep. And I'm glad you're going back out. I mean, I know it's a pain, but that's what's required by koma. So, what else is required by koma? You have to have a complete motion, must be reflected in the minutes of the meeting, and retained as a permanent record. There's really no laws in Kansas on how you write your minutes. It could be barely made. But the one requirement that's out there is that the complete motion must be reflected in the minutes. And we have found that the Attorney General has recently found violations for cities that aren't doing that. And they've actually fined their cities. So you have to be very careful to do that. And then minutes, of course, should reflect when the open meeting resumed. We talked about this again. You must return from an executive session to an open session and then adjourn. And binding action is required in the open session. So if there's anything you come to a consensus to in your executive session, you need to come out and to take binding action in the open meeting. One of the things we have found, I believe again, just a common question is, well, we terminated the person, but we did it in executive session. So technically that person isn't terminated. And if you have the authority to terminate someone, you have to do it in an open meeting. You can't come to a consensus and then just announce they're terminated and not pay them anymore. It doesn't work that way. They're still an employee until you do it in an open meeting. So common questions that we get.
Real quick, I don't think we've ever done it, but could you take action on what was discussed in executive session immediately after executive session? I don't think we've ever done it, but I think we.
One more time. So go back and open it.
Yeah.
No, since it's not.
Recent.
Okay.
We haven't done recent.
No.
In
each other.
Yeah, we're texting, we're talking, we're
No, I think y'all have, not just me.
So,
But you can do it for I mean, for sure, I don't know, I'm trying to think of an example, but if you wanted to hire someone.
well, termination, something.
Or
Executive, yeah.
Yeah, and you went into executive session and you were explained why this person needed to be terminated, and you were like, oh, yeah, they need to be terminated, you would come out to an open meeting and then you would terminate.
So when you guys want to terminate Chris,
Chris
have a
has to-
discussion.
No, because I'm a city administrator, I can't fire any department heads without your permission.
So-
You guys have to sign off on department head terminations, unless they
I can
resign.
be signed on the time.
Yeah.
But we-
Yeah. So if I wanted to get rid of Caitlin, I would have to go into.
You have to go
executive
through us.
session. I would have to go, or I'd
We
have
got
to.
your back.
Or I'd have to make it worth their while to resign, so we don't have to do that. But yes, so we would go in and then likely we would get out of that meeting and someone would we adjourn back into session and then someone would make a motion to terminate.
And as your lawyer, I wouldn't want you having the discussion of the substance of termination in open session.
That'd be the only thing you could say, vote to terminate. Roll.
Maybe you just say, I don't discuss personnel matters.
Thanks, guys.
It's not you, Keelan.
I mean, if the dinner would have been at like 7:30 instead of.
Okay, so more common questions that we get, who may attend? In previous trainings, we would have always said a governing body member had the absolute right to always be in executive session. That actually changed in October 2023 because the Attorney General issued an opinion. And it was a question from a groundwater management district, but that's still a public agency and it would still apply to cities. But essentially, the Attorney General concluded that if your governing body member is suing you or threatening litigation against you, then you can prohibit that person from going into executive session if you're talking about that litigation with your attorney.
God, I didn't share the odds, I think.
Yes.
So, and before, that, this had happened for years before. It's not that common for a council member to sue, but it does happen. And before that, we had always been told, and it was everyone's belief that you could not prohibit a governing body member from attending executive session because they were an elected official. But we have changed our opinion based on the Attorney General's opinion. As for everyone else, staff members, it's up to the governing body to decide. Of course, you need your attorney for attorney-client privilege, but otherwise it's up to you on who you bring into the room for executive session.
Like department heads or assistant city administrator.
Right, depending on whatever conversation you're having, but of course you want to keep it as private as possible, so the fewer the people, the better. Minutes should never be taken, that's another question we get a lot, which is very scary. If papers are passed out, they should all be taken back, right? No one should go out and remove any papers. We talked about this a little, you can talk about more than one subject, but, so if you had to fire several people in one night, you could talk about it, I'm not such a, but you could, I'm getting wax the whole time.
So we could do Chris and Caitlin at the same time if we were.
Yeah, that would be horrible, but anyway.
Horrible but legal.
But legal. But if you needed to do, Chris's performance review and the acquisition of property, like we talked about, two separate motions. You can't take a vote, but you can come to a consensus. There is no time limit for executive session. It sounds like you've all been through this, but basically the time limit is what you put on yourself, so what you put in your motion. If you end early, that's fine, you can go back out to the chamber, but you can't start your meeting until the time you said you would start it. And then also, if you need longer, you need to send at least those 5 people out to do another motion and go back in. And of course, executive sessions are meant to be confidential. So I think everyone would be surprised at how often we get a phone call of, we know a council member talked about our executive session because their name's in the paper along with everything we did in our executive session. And that's, technically everyone has a First Amendment right. There's no punishment for doing that. But there is a punishment of, you have let your staff down, you've let your governing body down. There's a question of whether you can keep things confidential. confidential, you open your city up to risk and litigation, especially if it's, there's a reason you go into executive session. These are private matters. When you're talking about employees, when you're putting the city at risk, when you're acquiring property and you say, well, we're gonna spend up to this amount, right? That's your negotiations over at that point. So there's so many things to think about.
Would that be grounds to exclude that individual from executive session?
No, you can't exclude them. So they can talk to the paper every night after, and there's nothing you can do, and it's super frustrating. But we always recommend, for good governance, keep executive sessions confidential. Okay, any questions about that?
But we also had discussions after the fact that in-house, that wasn't really the right thing to do. But we did do that, yes.
Okay, I have a hypothetical, and then we'll start talking about KORA. But just to give you a hypothetical. So is this a koma violation? Let's say someone has emailed a citizen has emailed the entire council concerned about something. And someone on the council accidentally hits reply all and responds to the citizen, and all the other council members see the response. Does that violate KOMA?
Depends on the response.
Or does it need a second council member?
Right. Because you don't have interactive communication. Your interactive communication is between the city, or between the citizen and one council member. It's not interactive communication between two council members.
So
So technically, if Chris texted the whole group and everyone, and one person responded back, you haven't violated KOMA yet, if there isn't interactive communication, because Chris can't violate KOMA. But when a second person accidentally hits reply all and responds to the citizen and says what they think about, their response, then you have interactive communication. So that's where you have to be so careful.
So it's probably a bad idea, but legally, Chris and I can have a conversation via email and CC everybody else, and as long as he and I are the only two people.
Legally, yes.
Okay, but it sounds like a bad idea.
The terrible thing.
Right.
And Chris would be like, stop. No, but yes, technically,
Okay.
because it's not an interactive communication between the council members, it's an interactive communication between you and someone who can't, isn't even a part. Okay,
But Ruben could still tell everybody, hey, I discussed this, you would email everybody and say, this is what we discussed.
Because I might do a report.
yeah, you just have to be
No,
so careful. And careful with residents, right? You may not even, it's just something to think about. Okay. So let's talk about, any more questions about KORA? Right, if you think of any, let me know. We'll move on to KORA. We'll move on to this book. And there are some actual big changes in KORA in 2025, so we'll go through those. Okay. So, a little history about KORA. KORA was enacted in 1984, so over 40 years ago, and it was declared that the public policy of the state is that public records should be open for inspection. KORA is to be liberally construed and applied to promote this policy. So this means that as a general rule, a record is open for inspection, and you have to provide it if someone asks for it, unless there's an exemption in the law that allows you to close it. Something else that I always point out at the beginning of KORA trainings, because it can be confusing, and we get questions about this all the time, but the Kansas Open Records Act does not contain a record retention policy. So there's no requirement under the act that tells you how long you need to keep records. So if you don't have a record that someone is requesting, you don't have to provide it. And I don't know if the city has a record retention policy, so you would follow what the city record retention policy is, and there's no state law. And once you get rid of those records, according to record retention policy, then they're gone and you don't have to provide them. All right. So something that's likely reviewed, obviously, is the public agency definition. exception. We know as the city that you fall under KORA. I would like to point out though that this is different than the koma definition of public agency. So sometimes a public agency can fall under one, but not the other. So sometimes they may fall under KORA, but don't have to have open meetings. So that makes things a little interesting. And I also want to point out the very end of that sentence where it talks about any other entity receiving or expending and supported in whole or in part by the public funds appropriated by the state or by public funds of any political or taxing subdivision of the state. Sometimes determining if an entity falls under KORA is not easy. Like KOMA, you have to look at those specific facts. We're not going to focus on that today, but I just wanted to point that out and the differences in the public agency definition between KOMA and KORA. Before we move on though, I want to make sure everyone knows about the two exceptions to the public agency definition. So the first one is if an entity falls under one of these exceptions, they do not have to follow KORA. And that first one, any entity solely by reason of payment for public funds for property, goods, or services of such entity. So the contractors you pay to mow or to fix your streets, because they're receiving public funds as contractors doesn't mean they have to follow KORA. Unless, and this was a law that was changed back in 2005, so at this point it's over 20 years old. But if you give money to a not-for-profit entity, and it's more than $350 in public funds a year, then that organization has to be able to show how they received the funds and expended the funds. And if they don't segregate those public funds and can't show how they did that, then their books are open to everyone. So that's one thing. So for example, if you give $100, I would say to an actor or something, they don't need to report how they spent that money because it's $100. But if you give $350 to the chamber, they have to earn more. They have to be able to show how they received those funds and expended those funds.
Real quick, can you go back a slide? Because if we had a committee that doesn't have any control of their funds, would they be subject?
And if it didn't have a form of council members.
So I would need more information, but and supported in whole or in part by the public funds. So you're talking about a committee here, like under the council?
Yeah,
That's still I call for KORA.
because they're supported by public funds.
Or any other entity receiving or, that's, but you're still, it's part of the city. So we say that anytime. But that's a good question, because it does talk about receiving or something.
But that'd be under the political subdivision of the state, right?
Yeah, I would say all your committees, they would all fall under KORA and we would whatever. I guess I don't know how to make that argument.
If we go back to the not-for-profit entities versus contractors, the not-for-profit entity has to be able to show how the funds were used. But the burden is on the not-for-profit entity,
Yes.
not on us.
Right, and it's only if someone even asks them, right? They don't have to show you how they did it, but if you ask them, they have to
But
provide.
they don't, it's not that someone asks us to make them show it.
No.
They have to go to that agency.
Right.
Ask.
Right. Good question. The other exception to the public agency definition, any municipal judge, judge of the district court, judge of the court of appeals, or justice of the Supreme Court. This is specifically for judges, not for courts in general, so it only applies to judges. And then we get to what is the definition of public record? What does that mean? And kind of like KOMA, there's three key elements. So you have any recorded information, regardless of form, characteristic, or location, made, maintained, or kept by, or in the possession of a public agency, or any officer or employee of a public agency pursuant to their official duties. So let's break that down and talk about that first part, any recorded information and what that means. So recorded information is evidence of the knowledge meant to be communicated. It's not notes, proposals, or drafts. And we'll get to exceptions later that make that clear, but notes and drafts and proposals do not meet the first part of the definition. The second part is regardless of form, characteristic, or location. So that's very broad, right? It ranges from paper to videos, text, pictures, or any digital information. And third, the final phrase, made, maintained, or kept by or in the possession of a public agency, or any officer or employee of a public agency pursuant to their official duties. So that means if you're a city employee and you use your personal cell phone for work and you have text on that cell phone related to work, those texts, like text to a council member or another staff member, those texts are public records, even though they're on your personal cell phone. And same with emails. If you're using a personal email for work, then those emails are public records, even if you're using your personal account like a Gmail account. It doesn't mean everything on your personal cell phone or your personal email becomes public records, but anything related to work, anything related to your official duties is a public record, no matter where you keep it. And that really came about years ago when it was discovered some public employees were keeping things on Gmail on purpose to keep them, they would have been open records otherwise, and they were keeping them on Gmail saying they were their personal records. So that's where this came about.
I got a question about that. So you said you put no drafts, notes, et cetera. So like prior to our city council meeting, we get the packet, and then I'm going through the packet and I have questions that I want to ask. That those don't count as public records.
Right, those don't count. Those that you have to don't count. Yep. Okay, and then on top of the exceptions to the public agency definition, the legislature has also carved out exceptions to the public record definition. So some exceptions are records owned by a private person or entity and are not related to functions, activities, programs, or operations funded by public funds. So this just ensures that if someone accidentally, leaves a record, like if someone was in your meeting downstairs and they left a brochure or a document of some sort on accident and on a chair, that doesn't just make it a public record, right? It's still theirs privately, which doesn't automatically become a public record. I always think like how many public records the library would have, right? For all the things people need the library.
So like if I text Stacy about our kids getting into the play, that's not public record.
Right.
But if I text Stacy about, are we taking both of my kids to XYZ public event?
Well, that's we're getting to an exception that I think you all will like. And actually, it's perfect timing. Any records made, maintained, or kept by a governing body member are exceptions to the public record definition. So that text is not a public record. Well, is it on your personal cell phone? Yes, so it's not a public record whatsoever. So the league interprets this to mean that if the city gets a KORA request for records of a governing body member, and they are on the governing body member's personal account, or at your house, or on your cell phone, or wherever it is, and the city itself doesn't maintain it, the city can't access it, then they are not public records, and you do not have to provide them. So, now, we also have the opinion, and this varies, that Ryan may have a different opinion, and that's fine, because this is a very big gray area, and there's no really good answer for this. But if you have a city account, then there's a question on whether those are exceptions to the public record definition. Because they're certainly made, maintained, and kept by you, but they're also made, maintained, and kept by the city because they're on the city server. So there's a question about that. But that has never been decided in court, and I think there's a good argument that they aren't public records. I think it could go either way.
That would be like our email. That would be like our city email address or something.
So I think you also, this is one place where I've seen koma and KORA intersect So if you're discussing matters with fellow members of the governing body via your personal text messages, that isn't an open record under KORA, but if there's an allegation of a koma violation, then the DA or the AG can come in and subpoena those records, even though they're not open public records, and we'll have to disclose them.
Right, that's, you have, and that, I was going to talk about that, so just because they're not open, if the city ever had any litigation, it doesn't mean that you would not have to provide them. So you still have to be very careful, because even if you're writing something about a planning and zoning, like a special use permit, let's say, I'm just trying to think of something hypothetical. If you're not going to approve a special use permit, and that person ends up suing the city, and you have records in your Gmail account, or text, just because they're not open doesn't mean they won't get them in litigation. So that's why you just have to be so careful, right?
Yeah.
I have a question, I'm pretty sure you answered it, this isn't a violation and isn't discoverable, but I have multiple email accounts obviously on my phone, and for some reason my phone likes to default to my Merriam account when I initiate an email, but sometimes I'm actually emailing about my 9 to 5. Is that discoverable at all? Because I'm not talking about city stuff.
It's not a violation, or it's not a public record, because to be a public record, no matter what, like even if Chris or Caitlin were writing a personal, like something not related to work whatsoever, if it's not in your public agency pursuant to their official duties, like if they had a picture of a child on their computer, that's not a public record, right? I don't think it is, because it's not related to their job, they just have a picture. So just because it's on their work computer doesn't mean that it's a public record. And that I would know, but in whether it's just, I don't know why be discoverable in litigation for the city unless it was related to something that you were being.
It's not, I just, work,
But I
have very
understand why that
sensitive
happens. Yeah.
topics or information, so when that happens, it always makes me different.
Yeah, it's not a public record,
Okay.
because it's not related to your official duties. So. Okay, then the next exception is records of employers related to the employee's individually identifiable contributions, half of employees for workers' compensation, social security, unemployment insurance, or retirement. These are just individually identifiable contributions. You would have to, if someone wanted to know what you paid for all employees, you would have to provide that. All right, questions about that? I just want to make sure I got your like on that. Oh, one more thing to go. I knew I was forgetting something. One more thing about this exception for governing body members. If you then, let's say you do have an email, but you forward it to Chris or you forward it to another staff member, then it becomes a public record because they have it at that point, or intentionally. That's when it becomes a public record. So, just to let you know about that.
Don't send those pictures of your kids.
No, I don't think that would.
I'll immediately delete it so I won't have it.
All right, then we're going to talk a little bit about core requirements. And these are all requirements that are in state law, so I feel like this is all things I need to go through. And I realize it's not the most exciting part about core. But the first requirement is that cities must have procedures for requesting access to and obtaining copies of records. And this starts on chapter 2, page 21 of your book. And then along with having a procedure, there are certain requirements your procedures need to have. So the procedures you adopt should provide full access to public records. It needs to protect public records from damage and disorganization. Your policy also should indicate that it's in ways to prevent excessive disruption of the agency's essential functions, that you'll provide assistance and information upon request, and then ensure efficient and timely action when you're responding to court requests. And if you look I'm sure you have a policy already, but Appendix F gives you a sample policy in the back of the book too. All right, the next requirement is that every city, regardless of size, must appoint a freedom of information officer or FIO, and then state statute lays out duties for the freedom of information officer. So under KORA, FIOs are required to prepare and provide educational materials and information concerning KORA, and be available to assist the public agency and members of the general public to resolve disputes relating to KORA. And again, this is all in state law. They have to respond to inquiries relating to KORA, and they have to establish the requirements for a KORA brochure that must be available to the public. So if you look on page 25 of your manual, you'll see a KORA brochure. And this exact one is not required, but actually every city in the league has these. If you fall under KORA, you're required to have a brochure wherever people can make a request, a KORA request. So this is one you can copy and just put wherever KORA requests are made. We have them like when you first walk in at the top of the desk at the league. KORA also requires public agencies to provide suitable facilities to inspect records, and we don't need to go through all of that, but essentially don't put someone in a tiny room that they can't really get to or see. There are also requirements for hours for inspecting and copying records. So if you're open to the public, then any person may inspect public records during that time. So if you're open from 8 to 5, individuals should be able to inspect records from 8 to 5. If you happen to have a day off or, be in an office that isn't open every business day, sometimes it happens especially in smaller cities, then you are required, if you don't maintain regular office hours, you must designate reasonable hours for inspection and copying on those days. So that is something that's required. A common question we get is who may request a record? And anyone can request a record. It can be a resident of your city. It can be a company from a different state like Florida. It doesn't matter who or where they are from. Also, you can't require requesters to tell you the reason they're requesting a record. So I always say it's not our job to police KORA. It's not our job to decide if it's a good or bad reason for why they want the record. It's just our job to respond accordingly. And I have had situations lately where the email that's come through the KORA request is very spam-like, and there's serious concern from the IT department that it's a cybersecurity issue and not to respond at all to that email. So I get, well, what should we do? What if this is an actual KORA request? And it is a hard gray area, and I think always talking with Brian or an attorney to go through that, because I think I'd rather take the hit and violate KORA if I'm really concerned about a cybersecurity issue than respond to something and have a virus or something to that end. But working with IT, maybe your attorney will help you with that.
I actually had a jurisdiction that there was a virus attached to a certain individual's email, and their IT blocked them, and they made a complaint, and the AG supported the municipality.
Yeah.
Because we inform the individual that, there's malware attached to your email, and we're blocking you, you can submit a written request, and they continue to send emails. The AG's office actually supports that.
Yeah, I think everyone understands the cybersecurity issue. I mean, there was something going out, and even the Attorney General got it, like asking for all of these documents, and we had so many calls of, if we give these documents, we're afraid we're going to be hacked. Like, they're looking for documents of all our software and everything that it's just looking for us to be hacked. And the Attorney General had also received it, so that was kind of nice because then we could work with them and talk to them about it. And in the end, I don't know that any city responded to it. So if you do get things like that too, it's also a way to call us because we may be getting the same information from other cities and may not be able to tell you, oh, this is a trend, this is what's going on. All right, so there are 4 things you can require as a public agency. You can require the request be in writing. You can require the requester's name and address. Any information necessary to determine the records requested, and also proof of identification. In some situations, you can also require written certification that the requester will not use the names and addresses obtained from the records to solicit sales or services. And I say in some cases, because there was an attorney general opinion on this, there were some public agencies that when you filled out your KORA request, you also had to certify that you wouldn't use names and addresses to sell services. But not everyone is getting a record that contains names and addresses, right? Not all records contain that. And so this individual was not getting a record with any names or addresses and refused to sign the written certification. And then the public agency wouldn't provide them the record. And the attorney general said, well, you violated KORA. There was no reason for them to fill out this certification. So we always put that caveat. You can require a written certification when your record contains names and addresses, but only when they do that. Otherwise, I wouldn't make them fill that out. I'm sorry if that's moving. Okay. Then another question we often get is, how long do we have to respond? And so you're supposed to respond to the request as soon as possible, but no later than 3 business days following the request. So today's Monday, so if the city got a request today, you would need to respond by Thursday. Or if it's Wednesday, then normally you would respond by Monday, but if Monday happens to be a holiday, then you have till Tuesday. You have those 3 business days.
But it would be at end of business on Monday.
Yes.
Does it matter when in the day that request comes in? Like if it comes in at 9 a.m. versus after the office closes?
So that's a good question, and when you get a request after business hours, Ryan, how do you handle that one? Because that's a gray area that I never know. Because I feel like some people say, oh, we didn't get it till 11:59, so we didn't see it till 8 a.m. the next day.
I would count the day we received it, and then if we're not able to turn it around that quick, I'd use some of what she's about to go over.
Yeah, that's how I would be too, but I think other people have taken, we counted, and if you sent it after the business day hours, we'll count it as the next day when we actually see it. So I always take the more conservative approach, but I think there's a good argument both ways. All right, so you have 3 business days to respond, but it doesn't mean you have to provide a record within 3 business days. You just have to respond. And there's essentially 3 acceptable responses to KORA requests. So you can grant access to the records within 3 business days, which is hopefully the majority of your requests, right? That they're small and easy and something you can get done right away. If the records requested are open public records, but it's going to take a while to fulfill the request, you have to get records out of storage or do a little more research or maybe have someone look it over and redact some things out of them. You can give the requester a detailed explanation why access cannot be granted within 3 business days, but that the record will be made available at a later date, or you can deny the request. There are really only 2 reasons to deny access to a record. First is the requested record is not required by law to be disclosed, and we'll talk more about different exceptions coming up. There are times when records are public records but may be closed under KORA or another federal or state law, and a city can lawfully deny access to them. Or the second one, the request would create an unreasonable burden upon the public agency in producing the record, or was made with the intent to disrupt the agency. So, I recommend that you really don't ever use the second one unless you've talked with Brian. And the one time I can think when this was used, where it was lawfully and appropriately used, was we had a public agency where like 2 or 3 citizens would come in every afternoon and basically stand in the clerk's office and repeatedly ask for different records over and over again. And it was every afternoon. And they were doing that to disrupt the agency. They didn't want the clerk to work and get their job done, right? They were just there to disrupt everything.
Who made that determination?
The attorney, and then they sent the letter, and everything was in, right, they connected this with the water. But this isn't here just because it's going to take 40 hours to fulfill the request, or it's going to cost a lot of money to fulfill a request. There are ways that a city can recoup their costs and time for doing those things. That's not the purpose of this. It's really when someone has the intent to disrupt the agency. So best practices for denying requests. I always talk with your city attorney. I mean, some things are probably ones you didn't know automatically because you've denied it before, but I always recommend talking with your city attorney to make sure it's appropriate, and then put the denial in writing and cite the provision of law you used to deny the request. Technically, under the law, you're not required to put the denial in writing, but then I think there's always that argument, well, they didn't get back to me in 3 business days. This just covers you, so you can say, no, we told them within the time period you were supposed to, and we gave them the exact reason why. All right, and so you have to keep in mind some of this was enacted in 1984, and so I think some of these laws don't necessarily make sense anymore, but some other core requirements regard the supervision and inspection and copying. So custodians have a duty to supervise to the extent necessary to protect against theft of or alteration to or damage of a record. Copies should be made off-site if possible. If not, record custodians shall allow arrangements to be made for off-site copying. And that happened quite frequently. I mean, we're more digital now, but 15, 20 years ago, there were lots of small cities that didn't have copies, and they'd have to go to the bank or somewhere else in their city to make copies. So that's why these laws are here. And records may be removed only with written permission of the records custodian. All right, an exception to KORA, and this is something that I think seems pretty straightforward now, but was a big deal at the time it was passed, is that cities are not required to provide copies of public records by allowing a person to insert, connect, or otherwise attach an electronic device like a flash drive to a city computer or other electronic device. And there was a time when citizens were just bringing their flash drives and saying, just put it on my flash drive. And we actually had to get this put in law so that we could say we couldn't do that. So, and of course now I think everyone understands all the cybersecurity risks, but at the time we had to convince the legislature this was important. The next topic concerns fees and what public agencies can charge. So the legislature significantly amended this section of KORA during last year's legislative session, and the new requirements took effect on July 1st of last year. So under KORA, fees must be reasonable. The law provides that if you're providing copies of records, fees cannot exceed the actual cost of furnishing the record. So cities may charge the cost of staff time to review and redact the requested records, but cannot include incidental costs, like things you're paying for anyway, like the cost of electricity to the building, those types of things. If you are providing access to records maintained on computer facilities, you can charge the cost of any computer service and staff time. And new under the 2025 legislation is that cities should use the lowest cost category of staff reasonably necessary to provide access to or furnish copies of public records. So this new requirement is not a mandate that all requests be filled by the member of staff who has the lowest salary. Really, it's an effort to ensure that public agencies assess only those charges for staff that are necessary. So for example, the city gets a records request and it's straightforward and it can be filled, by a city clerk or other deputy city clerk or other office staff. it would be unlawful to charge time for your attorney or city administrator to fulfill that request. There are, of course, times when an attorney or someone on staff who is paid at a higher salary is necessary to fulfill the request.
I mean, isn't there a lot of gray area there that if you're asking a department director for their emails, or the department director can go through their own emails to find something? Versus like, if it takes Chris 15 minutes to find something because he knows where it's at versus an hour for Caitlin because she doesn't, it's cheaper for Chris to do it, even though he's a higher salary employee.
When it comes to, it's the lowest cost category, I mean, I understand, but also you probably know
We
someone.
treat it reasonably. We say, an intern's not coming and going through my computer to find records on my computer. If it's a record that's likely on my computer and I gotta look for it, somebody requests for it, they're paying for my time.
Right, or the IT person, or whoever else wants to look for it. And, I mean, hopefully Caitlin isn't taking 3 times as long as Chris, but I'm assuming it's being, so I can shore the search function.
Well, I think we get requests for all records and just, you know, Chris knows his way around the servers.
No, I understand, and it might be bringing in an IT person to do that all for you, right? So, but it's really just, this isn't about saying you have to do the lowest cost person. It's more just, you have to be reasonable, and you can't say, well, we're gonna charge Chris's salary for a record that was just on this computer that any of you know, most people have access to.
But if that search for the record requires dealing with confidential information or sorting it out through things that only Chris should see, or it would be grounds for Chris to
Yes.
charge Chris's salary,
Yes, or Brian.
or Brian, or
You do
depending
have
on
to
the
be a
nature
little
of the
careful
request.
on attorneys, only because, and this was the previous attorney general, but there was I think it was a city, there was a public agency that charged their full attorney's hourly fee, and, which seems like it should be legal, like, I think that's perfectly fine, because it says actual cost of furnishing records. But the Attorney General's office said it violated KORA because that fee was unreasonable. So, you do have to be careful with hourly attorneys. But for everyone else on staff, I think you charge the actual cost, and then you work with, to see for the attorney.
So Brandon, you want to lower your.
And I can't remember what the hourly fee was for those attorneys, but they said, whatever it was, they said. But again, actual cost, I think that's a little, I did not like that, I didn't agree with that. Okay. Let me see where I was. I just don't want to skip too far ahead. Okay. So, under the new legislation also, cities can charge for staff time based on the employee's salary or hourly wage, but you cannot include the cost of employee benefits in that fee. So you can't add what health care and all those other things would be. Also, a new requirement is that when requested, the city must provide an itemized statement of all the costs it incurred and charged to the requester. The itemized statement must include the hourly rates charged for each employee involved in making the requested records, and an itemized list of any other fees charged to provide access to or furnished copies. So this is something that cities have never had to do before, and it's a big change, and while it's only required if you receive a request, it's my recommendation that you really need to start keeping track of the time and training staff to do that, so that you can meet this requirement, because it's possible you could get the request for the itemized statement after you tell the requester how much they owe, and after you've spent all that time. And if you don't keep track of the time you spent, it would be difficult to follow through on this requirement. It also helps because then you have proof of like, what was our actual cost for furnishing this? So if anyone ever complained, you could say, no, this is the time we spent.
And if fulfilling this record request requires that employee to work overtime, does it include the overtime premium?
It's the actual cost.
Right, but they did one on Saturday. Well,
That's
they worked
what I
on it on
mean. I don't
Friday,
know
but they
that
had to
it's
come in on
necessary.
Saturday to do their normal job.
Well,
I mean, they worked 8 hours on this in a 40-hour week, and they still had 40 hours of work, so they worked 48 hours that week, 8 of it was overtime.
it's the actual cost, and there's no timeline on when you give a record, so I don't know that you need to pay someone overtime to fulfill.
So whenever you get around to it,
I think you could probably ask some people, sometimes it can take months to get a record from a public agency.
Sure.
I mean, I expect
And
expect
it's
all
not
of our,
because, and it's not because they're trying to withhold information, it's like legitimately, they don't have the staff to do.
I expect all of our city employees to be busy doing city work 40 hours a week. So this request that comes in for 10 hours of work should result in 10 hours of overtime.
Well, I think part of the job is filling records requests, so whether, you know, that's just part of doing business and part of your everyday. And maybe it's an exempt employee like Chris who has to do it, and so then he doesn't get overtime either.
Then there's an opportunity cost,
Yeah,
because he was doing this instead of what we want.
I understand, but, you know, there's also part of doing business, you need to see.
And also-
I don't think overtime, though, I wouldn't, unless you have a really good job. I'm sorry.
If the one person who's able to do it is very, very busy, that might be a reason to reply within 3 days, and if you can't get it within 3 days, you should still expect to get it by.
Right.
Okay, but it's only 6 months.
I mean, if you ask, I'm not saying that that's a good thing, but it has happened. All right, so let's talk about a little bit more about this itemized statement of particular. I think we already talked about that. Okay, so here's some interesting Attorney General guidance that came out in July of last year after this legislation was passed. And this is not in the bill, but, what you need to know is that under the Attorney General guidance, it says public agencies are not permitted to collect per-page fees for electronic and paper copies. So I can say that not every city is following this, because again, it's actual cost, and I don't think the Attorney General's office is looking at that. But essentially, in the past, there was a presumption that charging 25 cents per page for a copy was reasonable. That is no longer the case. With the new legislation, all core fees must be tied to the city's actual cost of fulfilling the records request. So that's where the Attorney General has indicated that because the cost per page is likely less than 25 cents to print, charging that fee per page is unreasonable. So I think we've been telling cities, like, look how much it is for the paper and the your copy, you know, how much it is to print a page, and that's what you should be charging. And you can also charge for staff time. Before, I think the 25 cents kind of included the staff time, especially if it was something small, but this is new guidance. The Attorney General also says a public agency may not charge a flat fee for records unless such a fee is specifically authorized by statute. So fees for public records must reflect the actual costs incurred in responding to the request, including the hourly rates of staff involved and any other itemized expenses. So I know many cities charge a flat fee for certain documents, like police reports or building inspection reports. You can look on many city websites and see flat fees for certain records. The AG's office is now saying that you cannot charge flat fees under KORA. So essentially, you have to look at the staff time that goes into it. And I've had a city call and say, we spend way more staff to, like, this will be more expensive now. But that's, like, their flat fee was less than what the staff time is, but that's just, you can't charge that flat fee.
Can you establish a flat fee off what the actual cost is? Hey, we know that if you want a standard police report that's less than 20 pages, it takes 5 minutes of the clerk's time, we make 45 grand a year, and we're gonna charge you $10 for it.
I think if you can show the that that's what the actual cost is, and it's for everyone, and yes, you can do that. Some cities are, I will say some cities have said, we're just not going to do it if we don't, we're going to itemize and say, this is how long it took. Because some of these building inspection reports take us a couple hours to figure out where they are. They aren't actually $10, they're,
And then we get
30
to
or 40.
charge the time you take to do the itemized statement every time we get the request.
I don't know if you get to do that.
That's what it just sounded like.
It's time required.
But
Oh, yeah.
it's something to think about. If you can show that this is the actual cost, then I think it's fine. I will say this guidance was a little surprising. So, and as long as you can show it's your actual cost, I think you're okay. But I also think it's important that you know that this is what the current guidance is. So, next steps. If you haven't done this already, because this law did take effect last year, but if you haven't done it already, is to review your fees and revise them if you need to comply with the legislation. Consider getting rid of the per page charge. I don't think every city has it. Some cities have said, no, it legitimately costs us this much money per page. We are charging this much money per page, and we can show you that it costs this much money. Like, we will. This is what it is. But look at it, especially if you're at the 25-cent per page mark. If you charge flat fees, again, look at those and make sure they're the actual costs. And look at the fees you're charging for staff time and adjust accordingly, because when was the last time they were updated? Do they reflect your salaries if they increase potentially, right? Are you charging for the full staff salary? It's also important to train staff to document the time spent on FOIA requests, because if you don't get an request for an itemized statement, because you never know what you bill, and also that will justify the charge. I think every city needs to establish a system for documenting the time that's spent on fulfilling the request. It doesn't have to be fancy, but just an Excel sheet or some type of sheet out there for everyone to keep track. And again, only charge for the actual cost. may want this information for someone responsible to an accident, you do not have to provide this information under koma. Next up is personnel records, performance ratings, or individually identifiable records. What you do need to provide when it comes to your personnel records is you have to provide the employee and officer names, positions, salaries, and lengths of service. That's it. So you do not have to provide resumes, performance reviews, timesheets, anything else that individually identifies an employee or applicant for employment. The next exception is information that would reveal the identity of an undercover agent or any informant reporting a specific violation of law. And I think of this like if someone reports a nuisance, you can potentially redact their name under this exception. Criminal investigation records. I'm not going to go through the exception, but criminal investigation records can be closed if they meet certain requirements. And the district court can always order disclosure. Then records of emergency or security information or procedures if disclosures would jeopardize public safety, including cybersecurity related information. So again, like where you can go in koma and go into executive session. Under KORA, you also don't have to provide any records related to security procedures. Then correspondence between a public agency and a private individual, other than correspondence that is intended to give notice of an action, policy, or determination relating to any regulatory, supervisory, or enforcement responsibility of the public agency, or which is widely distributed to the public by a public agency, is not specifically in response to communications from such a private individual. So a long paragraph, but two things I would like to point out here. So this covers correspondence between the individual and the governmental entity, regardless of who initiated the correspondence. So if a citizen has emailed you, that's covered, you don't have to provide this record. But second, the legislature's choice of the word individual rather than person excludes from the exemption correspondence to non-individuals, like so correspondence you send to businesses or associations or corporations. That would not be covered under this exception. So an email from a resident telling the city about a pothole near their home, that would fall under this exception. You wouldn't have to provide it. But the newsletter that you send out citywide, that doesn't fall under this because it goes out to everyone, it's widely distributed. There's also a Kansas Court of Appeals case that concluded a letter from a school board to an individual that put them on notice that they were banned from district property. Did not fall under this exception, it was an open record, because it met that part where they were determining a policy or determination related to any regulatory, supervisory, or enforcement responsibility. So that letter had to be open. The next exemption is plans, designs, drawings, or specifications that are prepared by a person other than an employee of a public agency, or records that are property of a private person. And this is really your community development or building code officers, the plans that they have, that falls under that. Then we have kind of what we talked about earlier, but notes, preliminary drafts, research data in the process of analysis. All of this, I'm not going to read it all, but basically if it's not final evidence, you don't have to provide it. So any research staff is doing, or notes that someone has written down from a meeting, or from a conference they attended, or anywhere else, unless they have been publicly cited or identified in an open meeting, or in an agenda of an open meeting, you do not have to provide them. And when we talk about, publicly cited or identified in an open meeting, when at the first meeting where the governing body even says, hey staff, we want you to do this, that's not the trigger where it suddenly is open. It comes later when it goes into the meeting, when you talk about it in a later meeting, or it's identified in the agenda of a later meeting. All right, records of a public agency having legislative powers that pertain to proposed legislation or amendments to proposed legislation. identify when such records are publicly cited or identified in the meeting or in the agenda, or distributed to a majority of a quorum of any body that has authority to take action. So this would be like if staff was working on an ordinance, that ordinance draft is not a record, a public record that has to be an open record that needs to be provided unless it's publicly cited or identified in an open meeting, it's in the agenda, or if it's sent to 3 of your council members. So if a draft is sent to, because it says distributed to a majority of a quorum, and when the quorum is 5, so a majority of a quorum would be 3. So if staff sent you a draft ordinance to 3 council members, then it becomes an open record, or you can't use this exception. And the same with research, kind of the same thing. Once it's identified in the meeting, on an agenda, or distributed to a majority of a quorum of the body, that's when it becomes open. Attorney work product is another reason to close a record. Records of utility or other public service pertaining to individually identifiable residential customers of the utility or service. Specifications for competitive bidding until the specifications are officially approved by the public agency. Sealed bids and related documents until a bid is accepted or all bids are rejected. And once the bids are opened and the bid is accepted or all bids are rejected, then it does become all of them become an open record. Public records containing information of a personal nature where the public disclosure would constitute a clearly unwarranted invasion of personal privacy. And for this, I would always talk with Ryan. But the one things I can think that automatically stand out are like a social security number or birthday or anything that would put someone at risk for cybersecurity or identity theft. That I would definitely use this exception for. The other things, if you're trying to just talk, you should always talk with your city attorney. Public records pertaining to a prospective location of a business or industry where no previous public disclosure has been made of the businesses or industry's interest in locating or expanding within the state. Once it's announced and put out there, then those records are open. But until then, you can close it under this exception. Engineering and architectural estimates, and I feel like we're almost done. An individual's email address, cell phone number, and other contact information has been given to the public agency for the purpose of public agency notifications or communications that are likely distributed to the public. And then this is the last one, and this is the newest one. Records of a public agency that contain captured license plate data or that pertain to the location of an automated license plate recognition system. And we have 1 minute left, so we're not at any questions. Cora, I always go through Cora too fast, sorry, but because koma, it just is a lot. There is also new case law, and I'm not going to go through the facts, although I find it to be drama and interesting. But in the end, this happened 3 years ago now, and I always joke that you could hear all the city attorneys scream when the case came out because we were but essentially, the Supreme Court decided whenever a person asks for an electronic copy of an electronic public record, a public agency must provide a copy of that record in the electronic format in which the public agency maintains the record, unless an exception is required. So that is new case law. So we say put everything in PDF. And tell everyone that you're providing the record in PDF. And it hasn't been as bad as people thought it would be. That's what I thought. Ryan, we have a different experience. But.
Isn't that creating a record book?
We'll talk.
But if the record exists to PowerPoint,
You can save it, yeah, that's just how you export it.
you can't, this is, you have to or don't have to?
So let's say someone asks for a PowerPoint. They want, So this all came about because a person wanted an Excel spreadsheet with all the medical data, and the hospital didn't want to provide it. Yes, and that was a concern. And it went back and forth, and between the AG's office said one thing, the district court said another, the Court of Appeals said another thing, and this is why everyone screamed out loud, because what's the decision? Like, how are we going to comply with this? But that's why our recommendation is to keep everything in PDF and tell everyone that you will provide it in PDF format unless otherwise requested. And we haven't run into any issues.
Well, we can take things out of PDF and put them back into it. I mean,
Well-
not we, I can do it, I can figure it.
But that was a big case that happened. It's now been 3 years, because it was in January, I believe, 2023, so. And it hasn't been as scary as it felt in the moment when it first hit. So, on that happy note, does anyone have any questions? Thank you for listening to me for 2 hours and for staying